Hey guys, welcome back to my channel. This is for legal reasoning, right? And I'm pretty sure we're going over chapter 2 of Thinking Like a Lawyer. I'm pretty sure we are. I'm sorry. I'm a little lost. But yeah, let's look at the in-class notes I got. Um, let's see. Most published opinions are appellate cases. That's true. Appellate cases are, well, the appellate court is the court that like it doesn't bring in new facts to the case or anything. They use the stuff that was already like in the original jurisdiction, like the original case where it was heard at. They just look over those facts and see if the law was like you know if the procedure went wrong at any point or whatever. Um, they can't really be like, yo, this person actually isn't guilty of murder or something like that. Like, this person isn't actually guilty or not guilty. No, really, all they do is look over, like, yo, was the procedures during trial, were they fair? Was it fair? Was the rule of law, like, fair? Like, stuff like that. Um, let's see what else we got. Yeah, already determined, stuff like that. Rule of law. Rules govern the questions. What if there's no clear rule? Oh, this is for lawyers. If there's no clear rule of law for your case or whatever, you can't really find one. Make it up, bruh. That's literally what I wrote in my book. Um, application of law to the facts. Oh, so we were talking about the no motor vehicles allowed in park type rule because the law cannot foresee every single possible outcome like that could happen. Like like is a drone allowed in the park? Like like what defines vehicle? Like stuff like that. The law can't see every single little detail there is. So your job as a lawyer is to, utilize that to your advantage. Find the cracks, something that could help your client. We also use the no one is allowed to wear blue. Wearing blue is a legal thing because um and we would and we were trying to come up with like ideas of what could we use to help our client who would be the defendant because he wore blue? Well, what kind of shade of blue was he wearing? Was he only wearing it in his house? He was made to wear the blue shirt by like his boss or something. And then we went and we looked at, well, what's the reason this law is in place now? And it was because the aliens are going to shoot us down and kill us if they see anyone wearing blue. So then that changes like what kind of argument you would be arguing for your client to make sense. And we picked like, yo, this dude was inside the house like wearing his blue shirt, so the aliens wouldn't have shot him down. Um, talking about what shade of blue you're wearing probably wouldn't work in this case, but yeah. What else do we get? Um, the holding. Okay, so we have the most common I holding is usually well, not common, but you have the majority ruling, which is literally the majority. This is what the majority thinks. Then you have the dissent, which is, yo, broski, I don't agree with this at all. And they'll just write the dissent. Does it mean anything really? Not too much. I mean, you can bring it up in like future cases for your clients or whatever just to show like, yo, this big honcho bro Supreme Court person, they dissented to this. It's kind of just, I don't know, maybe like kind of acts as like a warning like, yo, this is why I dissent because this could go wrong down the line in different cases. So yeah, we have dissent, we have majority ruling, and we have concurrence. Which concurrence, I'm pretty sure, is you agree with the majority, but just for a different reason, and then you just write your little opinion. Um, and then what else do we got? Disposition, affirm, reverse. Oh yeah, your disposition. It's usually they can either affirm, reverse, or remand, or a mixture of all three. Right? Now, let's see what I wrote actually in my notes because I feel like my notes didn't really correlate with what we were talking about in class. But like I got the right I'm pretty sure I got the right book for this class. In chapter 2, I saw stuff about like interpretation, why interpretation is necessary. And and like the three different types of interpretation: the plain meaning rule, contextual interpretation, canons of construction, and legislative intent. Plain meaning rule just means like you read the text just how it is, like the statute just how it is. You only look at what it says. Contextual interpretation means you see like how this word is used elsewhere, how like the word in the statute is used elsewhere. You look at everything like surrounding the statute. You just don't look at one line. You look at the big picture. And then canons of construction is like interpretive rules or guidelines courts use when meaning is unclear. So like some examples would be like every word is assumed to have a purpose. Like no, there's no filler words, right? Every word is there for a reason. Uh and yeah, that's it.